in March, and we'll have our third energy disputes webinar in July. So for this webinar, it is my real pleasure to have you all join us. Some of you may know EAIAC, some of you may have just joined us today for the first time. So to give you a brief background of EAIAC, it stands for the East Africa International Arbitration Conference, and EAIAC started in 2013 as a vision of 4 young women, we were young then, passionate to highlight international arbitration expertise in Africa and encourage capacity building and networking for African practitioners and foreign practitioners as well. So we held conferences in different cities, in different countries across East Africa. We are achieving our vision through our annual conference, through the Africa Arbitration Awards, which we started in 2019 to celebrate African arbitration excellence, through the Young Arbitrators Career Day, which we started in 2020, through the focused webinars, which we started in 2020 to address topical issues that we may not have time during the annual conference to address. And we also have post-event special reports. The EAIAC committee comprises of myself, Agnes Gitau of GBS Africa, which is an African market entry and investment advisory, Leyu Tameru of IAB Africa, an online resource arbitration in Africa, for arbitration in Africa, and Elodie Dulac, a partner at King & Spalding, based in Singapore. So coming back to this webinar, it's 2 hours. We will have a robust discussion, and we're thankful to have expert speakers on construction and infrastructure disputes in Africa, and they will be introduced shortly. EAIAC is thankful to our webinar sponsors and partners who have really made this possible. And the first sponsor is Al Tamimi, whose profile is there, which is an international law firm headquartered in the UAE. And they've been a constant supporter of EAIAC over the years. They have a robust construction and infrastructure team, and that is to be expected. They are headquartered in Dubai, which is the home of one of the tallest building in the world, the Burj Khalifa. We are grateful for the sponsorship of Masin Project, which is an international expert advisory firm that deals with construction, claims assessment, and management. And their profile has shown briefly on the screen. And we also have our supporting organizations, which is the Dispute Resolution Board Foundation, which is a non-profit organization dedicated to promoting the avoidance and resolution of disputes. And we also have the Royal Institution of Chartered Surveyors, or RICS, which is a global professional body of chartered surveyors that work in all matters to do with construction, real estate, the works. We're also grateful to our other EAIAC supporting organizations. We've had great support from the Africa Finance Corporation, the Africa Legal Support Facility, the East Africa Law Society, from Kenya, CIAB, NCIA, the Architectural Association of Kenya, ULS and ICAMEC in Uganda, TLS and TIAB in Nigeria, CRCICA in Egypt, LASIAC and CIAB in Nigeria, and CPMLP, among others. For this webinar, we are very delighted to welcome delegates from over 25 countries globally. And they have hailed from government ministries, from parastatals, from private sector developers, development financiers, arbitration centers, legal practitioners, arbitrators, and other professional services. And with those opening remarks, it is my pleasure to start this webinar and to say, as general housekeeping, on the Zoom platform, please make sure you give your answers on the Q&A tab, or you give your questions on the Q&A tab, which we shall answer. Our rapporteur today is Winnie Nakazi Kiberu, a young lawyer in her final year at Strathmore University and a recent International Vis Moot Court winner. It is now my pleasure to introduce the webinar moderator, Ms. Yasmin Nashawati, who is the International Development Manager of Dispute Resolution Services at RICS. She has a great passion of building substantial panel of dispute resolvers from RICS and also globally. And she's worked very efficiently in the global property development space in Dubai, among others. So with that, I now welcome you, Yasmin, to introduce your speakers and to take us through this session.
Thank you, Arimu, for that very kind introduction. It is a pleasure to be here with all of you today and moderate this panel of experts in the construction and infrastructure dispute arena. So delegates, welcome again to this session. As Arimu mentioned, I am Yasmin Nashawati. I represent the Royal Institution of Chartered Surveyors, and I will be acting as the moderator for this webinar. So some points on the agenda. This webinar is going to be 2 hours in duration, divided into 2 parts. The first part will be a 30-minute discussion on general investment and dispute considerations, and part 2 is 45 minutes on specific issues relating to construction disputes. The presenters will be sharing slides as they go through their presentations, and there will be a Q&A session after each part. There will also be a general question and answer session after the conclusion of both parts. At any time, at the bottom of your screen, you should have a Q&A tab, and you can feel free to type questions on them into that tab on any of the topics that the speakers are speaking on. So now, without further ado, I would like to introduce our speakers. Our first speaker in part 1 will be Mr. Osariu Orabosa Obide, who is the Vice President of Project Development and Investments at the Africa Finance Corporation. You can see his full bio here on the screen. Among his notable achievements is the fact that he recently led the origination, development, and financing of AFC's 60 megawatt wind farm in Djibouti, which is currently under construction. Osariu will speak on the potential for construction and infrastructure disputes development in Africa and financer expectations. Our second speaker in part 1 will be Mr. Andrew Sems, who is a partner and the head of construction and infrastructure at Al Tamimi in Qatar. His bio is also going to be shown shortly on the screen. Mr. Sims is identified in Chambers and Partners and the Legal 500 directories as a leading individual for construction law, project law, and energy law. Andrew will speak on the potential dispute areas in construction and infrastructure development and major lessons from disputes. We will then move on to part 2. Our third speaker is Mr. Rohit Singhal, the CEO and disputes expert at Mason Projects based here in the UAE. Mr. Rohit's bio will also come up shortly on the screen. In 2019, he was awarded with the prestigious Outstanding Expert of the Year Award 2019 by the International Arbitrators and Experts in Engineering Sector, UAE. Rohit will speak on construction dispute claims and damages assessment and calculation. Our fourth speaker is Mr. Paul Karikazi, who is the Managing Director of GIB Africa Limited and the Kenya representative of the Dispute Resolution Board Foundation. Paul has over 40 years of experience in infrastructure development, including in traditional contracting and PPPs. Paul will speak on dispute avoidance mechanisms under the FIDIC's Rainbow Suite of contracts. Our fifth and final speaker is Mr. James Gihari, a chartered arbitrator and the former chair of the Kenya PPP Petitions Committee. Notably, he was recently awarded the Order of the Grand Warrior of Kenya and a Kenyan State Award for his dedication to legal matters. James will speak on the challenges in PPP procurement with a focus on the Kenya case. And now, kicking off part 1, I will invite Mr. Osariu to give us his 10-minute remarks on the potential for construction and infrastructure development in Africa and the expectations of financiers. Over to you, Osariu. Sir, you're on mute.
Okay, thank you, Yasmin.
Thanks
for the introduction. Just to show, can you see my screen properly?
Yes, perfect.
Okay, so good day, everyone. My name is Osari Orabosa Obide. I work at the Africa Finance Corporation as Vice President for Project Development and Investments. What we do at project development is to provide early stage development financing to allow projects to reach financial close, which is at the point where they can attract financing for construction. So today I'll be speaking on the subject or the topic, potential for construction and infrastructure development in Africa, the financiers' expectations. So basically what will financiers want to look at in projects before they can provide that financing. But I'll give you first a bit of background about AFC, just for those who may not be well aware. So AFC is an investment grade multilateral institution. It's established by treaty among sovereign states. So we have a concept where we have member countries and shareholders, but our charter allows for a majority of that our shareholding has a majority of private sector individuals. So which is why we have a very commercial nature and as well as a DFI status. Today, I think we've made approximately about 8 billion in investment. We have made investments in about 32 countries, focused on infrastructure financing solutions. We have, I think we have a track record of delivering transformational projects in host countries. AFC is also one of the highest rated entities on the continent. It's I think about the third or fourth highest rated entity with an A3- rating from Moody's. And this has helped us a lot in growing our capital base and raising financing on lend to projects. We also, I think we have very strong project development experience, which is what we, myself and my colleagues at the project development division do, is to provide that expertise to allow to get our projects to a point where they can reach financial close. The other point to note is that AFIDA is also an association which we were one of the founding members, which is an association of project developers on the continent, and we try to foster development initiatives and being the voice of the sector. At AFC, we focus on 5 core sectors: so power, natural resources, transport, logistics, telecoms, and heavy industry. And again, these are some of the projects we've done in the past, which are quite transformational and have led the way for other projects to be done in the host countries. So as we go into the topic, I think one of the things you would notice is that I think there's no doubt that there's a vast opportunity for investments in Africa for infrastructure financing. There's in many African countries, especially in sub-Saharan Africa, there's we're lagging behind in terms of just key infrastructure like energy, road, rail. There's no statistics. There's no need to bore you with the stats. I think everyone can read the World Bank reports and they tell you how bad or how far off we are amongst all of these countries. And so there's always an opportunity. But although that there's that opportunity to finance, to create or develop projects, the challenge is that only 10% of these projects ever reach financial close. So what we mean by financial close is the point where the financiers have agreed and have put in money into the project, whether debt financiers, whether it's equity. So just to that term, I'll be using it quite a lot. And you can see that this is a reconstructed slide from the McKinsey report, which talks about it, a 2020 report, which says that during the project life cycle, where you go from project identification and writing feasibility studies, about 80% of the projects just basically drop off because there's you can't take them from there then on. Is either they die at the approval stages, seeking consent from governments, or governments are not taking these projects as priority. There's something just happens there. And I think in our view is that there's a lot of emphasis on feasibility studies. There's a lot of emphasis from donor agencies, funding feasibility studies, but there's that last mile that you need to go where you've found out that the project is feasible. You still need to spend at least 3 to 5% of the total project cost to put things together. So to select the EPC contractor, to select the technical advisors, to pay lawyers, to get all your documents in a row and do either additional studies, the environmental impact assessment, all of that money that is needed to get the project. So doing a feasibility study is not the end of the project. It's just the first step to saying that the project is indeed feasible. And that brings us to the point. So those activities between feasibility and when you actually raise financing for the project is where the bankability threshold lies. So for different banks, different financiers, they have their different requirements. So what you're trying to always do in that phase is to ensure that you're meeting at least a majority of the financier's requirements, such that your project is as attractive as it should be to raise the financing. And again, in our experience, this slide or this report from McKinsey is true because we see a lot of projects and the hit rate is really, really below 10%. And I think the slide gives a good summary of what happens in that process. And in terms of bankability, we say project bankability is key to unlocking projects, and again, without financing, projects don't happen. And the question is why? What's bankability, or what do you mean by a bankable project? The truth is that there's no defined acronym for it. It's just how do you mitigate all the perceived, prescribed, conceived risks associated with a particular project, and how have you distributed that risk or mitigated that risk in a way that gives the financier comfort that this has been taken care of. And so for us, this is what we do and ensure that the projects have reached the point where it's ticked all the boxes. So at the project identification stage, what are you worried about? You're worried about, oh, okay, are you in the process of getting a feasibility study? Do you have the money to fund the development costs, which is, like I said, 3 to 5% of the project, 3 to 5% of the total project cost. Are you going to be able? Who are you as the project sponsor? Who are you? Where's your money coming from? Do you meet the KYC requirements? Do you have the political and government support that is required to take the project to the next phase? What's your network? Who are your local sponsors or local partners? Because we sometimes see a lot of foreign investors come in and they have no local basis to get the project done. And that, again, can be a disaster. And then you get to the project feasibility, where you usually want an independent opinion as to whether this project is something we're just phantoming, or whether it's somebody's retirement plan, or whether this is indeed a real project. Because sometimes you find you go from dreams to ideas and then to real projects. And then you start seeking approvals from stakeholders. Is this a priority project for the government? And if it is, can we get the licenses? Can we get the government approvals? Can we get the required guarantees if necessary? And then you come back to the private sector, where you then get most of the contracts with either selecting the EPC contractor or who's the off-taker. In most constructs, you would have an off-taker either buying or paying for the infrastructure. Who's paying for the infrastructure, essentially? And then it's at that point that if all of this is done and many more, you then be able to raise the financing. Now, I have highlighted sponsors' equity and credit enhancements in the slide, and a PRG and PRI cover. Those are partial risk guarantee covers and all that. And one of the big issues, going back to my previous slide, when we say projects drop at this stage, is that what we are constantly solving for in most infrastructure projects is that we have utilities that are bankrupt or near bankruptcy and don't have the credit requirement to allow you say, okay, this guy's going to buy my electricity and I'm sure he's going to pay me. So we spend a lot of time working with the World Bank and other institutions like MIGA, ATI, to get credit enhancements to support whatever the government is signing as your off-taker or as your counterparty. And this is what usually takes a lot of time. And again,
I'm sorry to interrupt you,
Europe,
Osario. You have 2 minutes remaining. Apologies for the interruption.
No problem.
Thank you.
No problem. But in Europe and many other places where you have credits, well-standing utilities, or even private off-takers, this is less of an issue. Then you could talk about sponsors' equity. The sponsors' equity is usually an issue because you have private individuals who like to own 100% of their projects, but don't have the money to fund their equity because they have limited resources. And so this is something we find a lot very difficult, where sponsors just want to hold on to as much equity, but not coming to terms as to the fact that they have to spend the money to own the project. So there are a couple of other things. Since I have just 2 minutes, I will go to my to the last slide. So in terms of construction and related risk, on given that's what the focus is on, is that we do have certain things that the financiers would expect. So, for example, completion dates is a big issue. So you want to do a project that is done on a turnkey basis, date, time, spec setting project, such that you don't have any reason to go back to anyone saying that the project could not be completed in time. And this is why we have things like delayed liquidated damages built into contracts to ensure that the projects are done in time. In terms of plant performance, we also have those performance liquidated damages to ensure that the plants meet those standards. And again, these two risks, the delayed liquidated damage and performance liquidated damages, I'm happy to answer more questions on this later, is that financiers want to expect that it's the bonds behind these two risks is usually between 10 to 20, between 10 or preferably 15% to 20% of the total project EPC price. And that's something that you want to have in your project. If you don't have it, it's difficult to raise financing. You also have the warranties, and also that is also supported by a bond, and that's basically taking care of defects after the completion of the project. And then you also, like I said earlier, you're spending a lot of time on guarantees, whether they're parent company guarantees, because you want to ensure that the EPC contractor has support for has its parent company support on the project. The reason behind this is that most companies in our EPC contractors in Africa create a small shell company, and when the policy objectives of the main parent company is changing, you want to make sure that they are tied in to understand that even though your policy is changing, you must honor my contract and fulfill your obligations before you move out to other things. And again, force majeure is a big issue. And again, I'll be happy to talk about that in a bit, given the current climate for COVID, where this has come up a lot more. And we're finding that force majeure and EPC contracts are not as simple as you can find in the ordinary course of your projects, especially when it comes to force majeure under your government contracts. So I will stop here. I've had to rush through the slides, but I'll be happy to answer many more questions that you may have. Thank you very much.
Thank you so much, Osario. And please feel free to type any questions that you have into the chat box at the bottom of your screen. We'll look at questions after the next presentation. So thank you so much, Osario. If I could ask you to stop sharing your screen. And after that, where Osario has so well set the scene for what the climate is like in terms of finance expectations, I would like to hand over the virtual stage to Andrew Semmes. He's going to give us a 10-minute presentation on the potential dispute areas in construction and infrastructure development and major lessons that can be learned from disputes. So over to you, Andrew.
Okay, thank you very much. We're just sharing the screen as we do that. Very pleased to be speaking today from Doha. I know that the majority of the audience today is in East Africa, and what I'm hoping to do is perhaps start on a general basis and then work through with a bit more detail and hopefully prompt some questions in respect to the question and answer session and generally. So,
Andrew, just before you begin, can I ask you to go into slideshow mode just so that we can see the slides clearly? If you go to slideshow, start slideshow.
Can you just bear with us?
I'm sure everyone is very used to any technical issues after a year of life on Zoom. Yes. We've just pushed that. Yeah, perfect.
Okay.
Thank you. There you go. Sorry.
Thank you very much. Right. So dealing with the first slide. This doesn't seem to be working. Can you move it forward, please? So the first slide is one which is just trying to get a few general themes. Why am I telling an audience of mainly people in East Africa about some statistics relating to the economies of Africa generally? Well, I'm just trying to get a sense that you can see that obviously different parts of the continent are progressing in terms of economic growth at different paces. And clearly, obviously, these statistics are somewhat out of date because all of the economies of the world, and Africa's no different, have had some sort of impact felt as a result of COVID. But one of the things I wanted to emphasize here is that with economies in different stages of development, then there are different sectors which are involved in the construction sector. And those different sectors will be using different contracts. They'll be in jurisdictions with different laws. They will be in places where the construction circumstances are generally very different. Of course, there are going to be themes that are consistent across all of the different countries, but nevertheless, there will be distinct differences from one jurisdiction to another. And as the previous speaker said, of course, obviously there is one overwhelming impact at the moment, and that is of COVID, and that very much does play a part in relation to a lot of the disputes which I'm currently dealing with, particularly in my own immediate region of the Middle East, but then also where we're being asked to look at things by our clients who are working in Africa. My next slide is one which also is a more general slide, but what I'm trying to illustrate there is just what might be the preconceptions and thinking of the investors who are coming into Africa. What we've got there is a very clear indication that China is by a long way the most influential of investors, and I'm sure I don't need to tell this audience about that. But what it does beg is in relation to each of those different countries, when it comes to the contracts that they want to enter into, what's their thinking relating to the choices that are available to them? Now, most jurisdictions will allow for there to be a choice of the law that's going to govern the contract. That's not the law relating to where the project is itself, but how the contract's going to be interpreted. There's going to be an opportunity to choose what sort of dispute resolution you have. And in my experience, you can sort of bracket the countries as follows. So the Europeans will invariably be quite comfortable or would prefer a civil law tradition of law governing the contract. And more often, they will want to have their disputes heard either in Paris or in Zurich. By contrast, British companies and the US companies are much more comfortable with the idea of a common law type law to govern the contract, and we'll often be looking for the London as being the centre for any dispute resolution. The Chinese, by contrast, obviously will have real difficulty in persuading anybody that there ought to be Chinese law that applies, and secondly, that it ought to be Chinese dispute resolution. And what we're seeing more often than not is that the Chinese companies are fairly pragmatic about this, but they're quite often keen on the idea of Singapore being used. Similarly, there is a willingness to accept the Middle East, particularly Dubai, less so Qatar, but certainly Dubai. And then in relation to Indian investment, well, again, the Indian investors, and some of the other panelists may have a view in relation to this, are again quite happy with the idea of the Middle East, potentially also England, and indeed Singapore has become significantly more popular for Indian companies. So the next slide is really then just to touch on what is it that we are seeing as being the main issues in respect of disputes on construction projects. Now, of course, Africa has probably more similarities with the rest of the world than differences. A lot of these things will be issues which are encountered around the world. But there's been various research done as to whether or not, certainly in more recent years, there's been a tendency for disputes to arise in one particular area rather than another by region. And what I've listed out there are, on the left-hand side in particular, are those in something of an order of priority of what's been encountered. And you know, I can leave you with those to read, and maybe it'll prompt some questions. But you can see that it's not surprising that changes in scope and late approvals are top of the list. Now, down the right-hand side, obviously, COVID is very much the issue that is on many people's minds at the moment. But then it's very important that you identify that within the African market, perhaps more so than elsewhere, as the economies gather pace and there is more and more investment, there are some deep-seated issues which need to be addressed in order to really make sure that we can avoid disputes as opposed to having them. And again, it's the same thing of late approvals, design failures. So the unrealistic timescales. I mean, in fact, what that is actually linked with is design, because more often than not, there is a real urge to get a spade in the ground, even though the design isn't properly complete. And much as that the risk may have been passed by the contractual terms, actually, in the reality, it would be far better off if the parties held back somewhat and only started when they'd actually firmed up on their design. And then I mentioned just settlement. It's possibly something that's cultural. Certainly we experience it here in the Middle East. But there is a real desire not to get into formal dispute processes. And within the African market, there is undoubtedly a tendency for settlement, where the settlement is around speeding up progress on site and getting the job finished. And often, irrespective of the contract terms, the employer will be willing to pay a premium to get the job finished.
Sorry, Andrew, 2 minutes, yeah?
Yeah, the final slide, just touching on some of those issues that I've already identified. Obviously, we're going to have some presentations in relation to the FIDIC forms. They are used widely in both the Middle East and Africa, but there are all sorts of bespoke forms. I mentioned that these are standard themes and issues wherever the location and jurisdiction, whoever are the parties, and whatever is the law of the contract. But and for those of you who are negotiating contracts, be aware of going into a negotiation with preconceptions about what you've experienced previously, because it is absolutely essential that with a little sort of a mnemonic or some sort of short table of things to be thinking about. So what is it that is the choice of law? Will that choice of law actually have an impact on some of the themes which or some of the risk issues that I've got in my contract? And I set out on the right-hand side there some of them. I mean, I'll just touch on one in particular, liquidated damages. It's been mentioned already. In many civil law jurisdictions, liquidated damages are easily challenged. In the common law jurisdictions, that is liquidated damages is a concept that has been enhanced by the law over many years. And if you've got a liquidated damages clause in a common law contract, English, Kenyan, Nigerian, then getting out of that, whether you're paying too much or you're paying too little, is going to be very difficult. I contrasted, as I say, with civil law, where it is potentially quite easy or easier to get out of it. And then finally, choice of dispute resolution. I've mentioned that most countries do allow for a choice of law and a choice of dispute resolution that's outside of the country where the project's taking place. Invariably, that's going to be arbitration. I would emphasize that there's all sorts of different types of arbitration. Not always ICC, which is an extremely expensive way of having your dispute settled. There are then other ways of other alternative dispute resolution, like expert determination, or a popular one in FIDIC is dispute adjudication boards, or all of which one would hope would bring the dispute to a conclusion faster and cheaper. So that's my set of themes. Looking forward to some questions. And back to the chair. Thank you.
Thank you so much, Andrew. We do have a few questions in the chat box. So Warimu, I'm going to actually start with the one from Ibrahim Kitu, and I think that would be addressed to Osariu. He's asked, it has been often stated that the African landscape does not fall short of financing options, but rather bankable projects. What strategy should be adopted to ensure that projects are bankable at the development and tender structuring phase? Osario, are you still there? Would you like to come off of mute and give your thoughts on that?
Hello, can you hear me?
Yes, I can.
Okay, I'm sorry, I'm trying to fiddle with this. I can't get the screen back on. Just give me one.
Paul has stopped sharing now. Maybe it'll be easier.
Okay. Okay, so so can I get a question again? Sorry.
Of course. So Ibrahim says, it has often been stated that the African landscape does not fall short of financing options, but rather bankable projects. What strategy should be adopted to ensure that projects are bankable at the development, at the development and tender structuring phase?
Okay, the truth about it is that there are two ways to it. So in the West, what happens is that the governments are the ones the government spends the money to do the development work. And it is only after they've done the development that it then brings those projects out for tender. So when the government is sending out a project, you have an environmental impact assessment, you have many of the documents in a row. So as a contractor or as a project owner, you are working within a sphere of documents that are already acceptable to the government. Now, in terms of some other places where PPPs have worked very well, you may not have all of that being done. So there's some expectation that the developer will do some work. Now, in the context of Africa, the challenge is that the projects that the government will announce, and most of the projects are not from the government, is actually led by the private sector. So people see, oh, there's an opportunity to provide power somewhere, there's an opportunity to do something somewhere. And it's based on that people then come up with those projects. Now, bringing a project and bringing it to ensure that the projects get to the point of bankability requires you spending a lot of money. Now, the question is, most times people underestimate what that costs. People think, oh, it's just sitting in my house writing a report, but it's more than that, because you have to pay lawyers, you have to pay everyone around. technician, consultants, and all of those to have your technical reports. And it's a long-winded process. So it's typically, on average, you find projects taking between 3 to 5 years just for the development phase. And I think the average in Africa is about 7 years. So there's a lot of work, there's a lot of money that's required. So it's either governments, in a nutshell, is either governments spend the money to develop the projects, at least to have proper feasibility studies, proper definition of the projects, and launch those projects as priority, such that the private sector takes it from there and will do the final bits of work to get it to the end. Or when there should be a pool of money available to private sector individuals who can access those funds to be able to then go and develop the project, because again, you're not going to use your retirement savings to get a project developed.
Thank you. Just in the interest of catching up on time, I'm going to combine two questions together a bit. So one is from Alois and one is from Mr. Nagawi. So Andrew, it's for you. It's about the enforcement of arbitral awards in Africa. And if you could also touch on when you choose the jurisdiction, for example, are there, certain choices of law that would be more prohibitive than others? So I know that's a very detailed topic, but if you could give a short summary.
In sort of very general terms. So, why we're in the context of international projects and projects that are situated in Africa, African jurisdictions, have I been talking about arbitration? Well, the history of arbitration in construction matters is a very, very long one. And the main reason is because there has always been a market for international contractors to move irrespective of jurisdiction. And so what you then have is whether it's a claim against the contractor or a claim by the contractor is enforcement in a jurisdiction other than, quite often other than, where the project takes place. And one of the problems historically has been that different court systems have actually been quite reluctant to enforce the judgments of other court systems. Goes back a very, very long way, and it's still prevalent today. So arbitration developed as something which would allow for enforcement internationally, and that's supported by a number of international conventions, the most well-known of which, with the most signatories, is the New York Convention from the 1950s. And so if what you've got is an arbitrator's award, then normally in most of and most African countries are signed up to the conventions, then that arbitrator's award you can take to the courts in the country where the assets are and enforce that in a way that you wouldn't be able to if you just got a court judgment. Now, not that then the question I think is possibly asking is, well, there's two sides of it, I suspect. One is, insofar as you get an award from an arbitration in an African country, would you then be able to go and enforce that in a country where the contractor, for example, has got its assets? And the answer is, in all likelihood, yes. I mean, it'll vary on the jurisdiction, but if the jurisdiction where the contractor's got his assets is a signatory, then that award should be enforced. Equally, if you're looking to enforce in front of the courts of your own jurisdiction, so in Kenya, Uganda, wherever it may be, they are signed up to the conventions and the courts should enforce. Now, look, I'm not trying to say it's easy. It's an expensive process to enforce an arbitrator's award, but it is internationally recognized. And one aspect, and it comes actually to a question about bankability, is whether or not the legal system in any particular country will follow the rule of law. And so whether your arbitration is enforced or not in your home jurisdiction in Africa is actually of serious concern to the government of your country in terms of its credibility. And so I hope I've answered it fully. There is every chance that your arbitration award will be enforced in Africa.
Thank you, Andrew. Andrew and Osario, there are a few questions in the chat box, question and answer box at the bottom. If you'd like to type answers, you can go ahead and do that. We are now going to move on to, yes.
Yasmin, just one remark regarding what Andrew mentioned. I think it's very important that it's very important what he has been speaking about, and just to make the point that these days, without international arbitration in your dispute resolution mechanism, you're unlikely to be able to raise money for your project. So it's as simple as that. And we've seen test cases in the first round of the Egypt solar projects where the arbitration that was requested was for local arbitration, and everybody just ran away. So it's just to show you that it's a very important point he's just raised.
Yes, I would agree. And I know when I was in Kenya for the last EAC conference, and it was face-to-face, it was how do they also keep African disputes in Africa and managed in Africa instead of always being sent to London or Paris or other jurisdictions. So it's, saying that they wouldn't agree to arbitrate in Egypt is an interesting one, considering that the Cairo Arbitration Center is, very, very well respected and quite an old institution in the region. So with that, we're going to move on to part 2 because I realize we are a little bit behind on time, but it's great that everyone is so engaged and asking such great questions. So that has all set the stage for a deep dive on specific issues related to construction and infrastructure disputes. And money, of course, is of concern in every domain of life, but most importantly when it comes to investment. And to kick off part 2, Mr. Rohit Singhal will share his insights on construction dispute claims, damages assessment, and calculation. So over to you, Rohit.
Thank you, Yasmin. And it's my pleasure to be giving this presentation to the esteemed audience. My name is Rohit Singhal and I represent Mason. Till now, you've heard about the financing of the projects, the implementation of the projects. You've also heard Andrew talking about the legal aspects of dispute. Now, let me as an engineer tell you how to calculate numbers, the amount of claim in case your construction project runs into delay or there is some changes in the specification scope, etc., etc. So I have a brief overview of how to calculate and the disputes assessment to be done, how to calculate the value of the claims. Now, I think majority of the people who are involved in construction projects would agree that one typical dispute which is always there between parties who are stakeholders in the project is related to delay. A majority of the projects get delayed because of some reason or the other, and both the contractor and the employer keeps on alleging that the delay is attributable to the other party. So an extension of time, a delay claim is very, very common. So when I say a delay claim, which means a claim put by the contractor on the employer, or probably vice versa, wherein an extension of time is being sought along with extra stay or prolongation cost, what we call it. So prolongation cost is basically the cost which a contractor claims on the employer for its extended stay of resources at site. Now, generally, a large chunk of construction contracts, and also in Africa, in case a contractor is delayed for reasons which are beyond its control and are attributable to employer, then additional sums have to be reimbursed to the contractor. Now, generally what happens is, and a very fairly common approach is that the contractor calculates its weekly expense, its monthly expense based on overheads and prelims, and then multiplies that monthly expense by the extension of time which has been granted. So let's say every month if the contractor is spending $100 and he has been granted 5 months of extension of time, so multiply 5 by $100 and you arrive at $500 as your entitlement for prolongation cost. Now, that's what generally most of the contractors are doing. But let me tell you, this is a wrong approach. And especially in international arbitrations, this will not be acceptable and it will be rejected. So the reason why this is a wrong approach is that number one, the expenses of a contractor does not remain same throughout the project. People who are involved in the project would know that at certain stage of the project, the expenses are less. As the project begins, as the project progresses, expenses are more. And then towards the end stage of the project, when the demobilization is going on, then also the expenses are less. And also this approach of calculating the extension of time multiplied by the monthly expense or the weekly expense ignores the concept of concurrent delay. And the concept of concurrent delay is that in case a situation is that employer and contractor have both caused delays which are concurrent to each other, they are running parallel to each other, then in that case, probably only an extension of time is to be granted and prolongation cost for such delay period might not be there. Generally, the law says that in case there is a delay which is caused by the employer, and let's say if it is party A who is a contractor and party B, which is the employer, causes delay to party A, the contractor, then party A has to be brought back into the same position had there been no delay. So therefore, the assessment of the prolongation cost, which is the extended stay cost of the contractor, has to be such that that whatever is the actual loss, actual damage suffered by the contractor is paid by the employer to the contractor. Now, in order to calculate this, the very first thing what has to be done by the contractor is to do a delay analysis and to find out and to establish that who has caused what degree of delay, or how much is the extent of delay caused by the employer and how much is the extent of delay which is attributable to the contractor on its own. So how do you do that? Generally, you do it by way of undertaking a delay analysis where you go through the delay events, you go through the programs and schedules of the work to find out what is the number of compensable delay days. Now, I would not like to touch about the compensable delay and delay analysis in this presentation because I'm focusing more on calculations of the prolongation cost and other damages. But delay analysis is an important aspect in order to calculate the number of days which are compensable. Now, once a contractor has undertaken its delay analysis and has been agreed with the employer that let's say 100 days of days are compensable delay days, then it has to be, the next step is to find out what is the cost for those 100 days. Now, in order to calculate the cost for those 100 days, as I said, it has to be based on actual loss, actual damage suffered by the contractor. And for those 100 days, so let's say 100 days could be even during the middle of the project, not necessarily after the contractual completion date. Generally, this is also a very big misnomer that the prolongation cost is only claimed for delayed duration or delay period, which is after the completion of the project, after the contract completion date. It's not. When you do a delay analysis, when you find out the critical delays, then it may be that the critical delays are caused by the employer even prior to the completion date. And then what contractor has to do is contractor has to find out what is the actual loss for those critical compensable days, whether they are in the middle of the project, starting of the project, end of the project, or after contractual completion date. So once an extension of time has been awarded, it does not mean that it automatically means a grant of prolongation cost to the contractor. This is another very big misnomer, which is there. A confusion is there always in the mind of contractor that if I have been granted an extension of time of 100 days, I'm entitled to immediately 100 days of compensation. That's not the case. The compensation is only going to be given for the compensable delay period, which could be less than 100 days. It could be 50 days, 70 days, depending upon what is the extent of concurrency within the extension of time which has been granted. The general principle under several jurisdictions is that in case a delay is concurrent in nature, i.e. it is caused by the employer and the contractor together, then time is given but no cost for such kind of delays. Only where the delay is solely attributable to the acts or breaches of the employer, then in such instances, those delays delay days gives extension of time as well as cost. So the necessary condition to recover the prolongation cost is that delay has to be solely attributable to the employer, and also the contract conditions allows the contractor to claim such kind of prolongation cost.
Sorry to interrupt, Rohit. 2 minutes, yeah?
All right, thank you.
Thank you.
So once you have calculated those extent of number of days of compensable delays, then the next thing is the contractor will have to go back to its financial records to calculate what is the actual loss which has been suffered, or what is the actual time-related cost which it has incurred during those compensable delay durations. Now, what do you mean by time-related cost? Now, time-related cost means those costs which increase as the time of the project increases. Now, time-related cost does not include the resources or the work-related cost. Time-related costs are generally what we call as overheads. For example, camps, for example, engineering staff, for example, project management staff. These are some of the time-related costs of a contractor which can be claimed under prolongation cost. But in case it is labor, mason, carpenter, welder, these are work-related costs and cannot be claimed under prolongation because it is considered that they are being claimed under the work-related heads, and maybe a delay in the project might not have resulted in extra expenditure of the contractor towards these resources. So to conclude, basically, it's not simply that a fixed cost is calculated on a week or month basis and multiplied by the prolonged period, but the prolongation cost assessment has to be done based on actual loss, actual damage basis for the time-related cost. For the resource-related cost, there is a separate claim, what we call as a disruption claim or a loss of productivity claim, which has to be established separately. For establishing a prolongation cost, a contractor has to ensure that all its financial documents, ledgers, payment proofs, invoices for the time-related costs are made available to the employer, and that's what is the requirement in international arbitrations. So it is mandatory that a contractor keeps its documentation, backups, and unless and until those backups and documentation are not there, a contractor is at a very high risk of losing its entitlement for prolongation cost. Thank you. But before exiting my presentation, another thing is, in case a contractor intends to claim a variation or a change in scope or a specification, there again, the assessment has to be done based on actuals, or in case a contract has a condition that the unit rates or the bill of quantity rates given in the contract have to be used for the assessment of variations, that can be another way subject to the contract conditions. But otherwise, the general principle which has to be kept in mind is actual loss has to be claimed. Thank you.
Thank you so much, Rohit. There are some questions in the chat box, but we'll get to those after all the other speakers have finished. So next up, we have Paul. So Rohit has talked about the financials to consider what to do when it already has escalated into a claim. And you're going to speak, obviously, about what we can do to actually avoid disputes, which is very interesting. RICS has also had great success with the concept of conflict avoidance on infrastructure projects in the United Kingdom. So thank you for that. And would you like to begin now, Paul?
Yeah, thank you, Yasmin. Now, for those who may not be familiar with the FIDIC forms, the Rainbow Suite of FIDIC consists of 3 books, generally known as the Red Book, Silver Book, and the Yellow Book. The provision to deal with dispute avoidance and adjudication are especially the same in the 3 forms. Now, the construction industry has a reputation for disputes and conflicts. Evidence from Australia indicates that 50% of all legal costs associated with construction are expended in connection with disputes. In almost 10% of projects, between 8 and 10% of the total project cost was actually legal costs. So this expenditure does not consider the hidden costs of disputes, that is, the damage to reputations and commercial relations, the cost of time spent by executive personnel, and the cost of lost opportunities. So basically, the idea of a project-specific dispute and or claim resolution procedure, which will be ongoing and stay as part of the activity from start to the end, gave birth to the concept of dispute boards. Now, what is a dispute board? It is different in many ways from other forms of dispute resolution. For start, it is specific to the job site. And as a dispute adjudication process is typically, it comprises 3 independent and impartial persons selected by the contracting parties. The significant difference between dispute boards and most other alternative dispute resolution techniques is that the dispute board is appointed at the commencement of a project, before any dispute arises and before any event has occurred which will lead to a dispute, and by undertaking regular visits to the site, it is actively involved throughout the project, which underpins the dispute board philosophy. Available data shows that to date, there have been about 16,500 disputes in construction, which have been referred to dispute boards. But of those, only about 60 have been referred to arbitration. And even at arbitration, most of them, most of the decisions by the dispute boards have been upheld. Now, dispute boards are applicable to various sectors, including PPPs, power stations, railways, and so on. In terms of the evolution of dispute boards, it started a long time ago, back in the 60s. So it's been evolving over time from a form called Dispute Resolution Board, where the determination or the resolution of the board was non-binding, to what we have today called DAB, which is Dispute Avoidance and Adjudication Board, where the decision which is eventually binding on the parties. Now, if we look at the mechanism that is embedded within the Rainbow Suite of 2017, it is a 3-tier dispute process. So in the red and yellow book, the process starts with the engineer addressing a claim from either party, and if the claim is not resolved at this stage, then it progresses to adjudication by the DAB, and on to arbitration if the decision of the DAB is not accepted by either party. In the case of the silver book, that is EPC turnkey, that's the silver book, the claim by either party are addressed by the employer's representative and follow basically the same process as for the other 2 books. Now, what the forms have done, they have extended the role of the engineer or the employer's representative in this case. So the engineer in the red and yellow books has a central role. He's involved in all aspects of the project from start to finish, and his success or failure depends significantly on his willingness and ability to perform his duties properly. In the FIDI contract, those duties are essentially twofold. First, the engineer administers the contract, and secondly, he has the function of seeking agreement on, or in default, determining various matters arising under the contract. The only difference is that in the silver book, this is performed by the employer's representative. Now let's look at the sequence of events as embedded in the 3 forms. And what I want to show you here is the issue of consultation. And there are 3 scenarios. One of them is where the parties reach agreement following consultations, which have been basically, shall we say, encouraged by the engineer or the engineer representative. So there is an obligation placed on the engineer or the employer's representative to create an environment where the parties can reach agreement. That is an obligation which was not in the previous forms. So you'll see that in all 3 scenarios, whether the agreement is reached between the parties or not, there is 42 days set aside where the engineer is required to perform that duty under clause 3.7. Now, what is the composition of a board? So generally the World Bank and FIDIC recommend that for a small project, that is a project under $50 million, that a one-person board should be appointed. However, you can see there are very many differences. Like, for example, if you look at the Channel Tunnel, they had 5, Hong Kong, they had 6, and so on. So it really depends on what the parties need. But generally, like in Africa, in most cases, you'll find that it's a board of one person if it's under $50 million, or 3 persons if it is more than $50 million. How is a board appointed? Now, this is a very important aspect of a dispute board. Typically, each party selects one member of the dispute board, and these 2 then select the 3rd member, who, with the approval of the parties, then acts as the chairman. This is sometimes referred to as the bottom-up selection process. Another approach sometimes which is utilized, where the parties choose the chairperson, who then selects the other 2 members of the board. And this is normally called the top-down selection. But appointment of a party is not, you're not choosing a representative for the party being making the appointment. The members are to serve both parties with total impartiality, and members' independence is paramount as a dispute board that is perceived as partisan will not engender respect, and its recommendation or decisions are less likely to be accepted. So dispute board members should be chosen with care, because the success of a dispute board depends on the party's confidence in the expertise of the members, particularly that of the chairperson, who must conduct the regular meetings and hearings fairly and firmly. So impartiality and objectivity are vital qualities and should not be compromised or appear to be compromised by a member having a professional or personal affiliation with the organization involved in the project. So what happens in terms of the sequence of dispute events envisaged in the FIDIC forms of 2017? So first of all, there is an obligation on the parties to appoint a board within 28 days after the letter of acceptance has been received by the contractor. This is a new introduction, it wasn't there before. And then generally the role of the board would be, as I said, to try and avoid disputes by offering opinions. And sometimes they can even request parties to request an opinion so that the claim does not fester into a dispute. But however, if all those efforts fail, then the DAB, so the DAB has got 84 days within which to render its determination. And then after that, if the parties are not satisfied with the determination of the DAB, they may proceed to arbitration.
Sorry to interrupt, sir. 2 minutes.
Yeah, I'm nearly done. Thank you. The next question is, do dispute boards, are they successful? Now, this question is always asked, but because of the confidentiality of the dispute board process, very little published information is available. However, available information, while scanty, does indeed confirm the effectiveness. A few examples as shown on the slide, I will not repeat them. So there's even one in very near us here in the Katse Dam in Lesotho, where there were 12 disputes referred to the DB. One went to arbitration, where the decision of the DB was actually upheld. With that, I come to an end. I will take questions if you have any.
Thank you so much, Paul. So we'll get to all the questions at the end. James Kihara, you're last but certainly not least. We know that most infrastructure development in Africa concerns governments, and that this is more often carried out through the use of public-private partnerships. We know that there are challenges and opportunities when it comes to these types of partnerships, and most of the mega disputes we have seen lodged are against governments. Based on your Kenyan experience, what are the challenges in PPP procurement? If you could begin your 10-minute.
Thank you very much.
Sir, if you just go to play from start. Yes. Okay.
Is that good enough?
Yes, perfect. Thank you so much.
Okay, thank you. Thank you so much. Now, what I want to look at today is the challenges that we are faced with when it comes to PPP procurement. And specifically, I want to talk about the Petitions Committee. Now, maybe first of all, a little bit about the regulatory framework. In Kenya, the regulatory framework, you can get it from the PPP Act, the Kenyan PPP Act of 2013, and there are several bodies that are created by that act. One of them is the PPP unit. That is the administrative unit of PPPs in Kenya. It is the expert body on PPPs. Then we have a body we call the PPP Petitions Committee. This is more like a policy body. It's like the board of the unit, because the unit comes up with the PPP, or rather approves a PPP, and the PPP committee again looks at it and approves it. The third body is the Petition Committee. The Petition Committee is a tribunal, so to speak. What does this tribunal do? This tribunal hears disputes. It hears disputes, it considers disputes or complaints from private parties in a PPP tender process. Now, you need to note there that it has to be the private party. Not anybody can file a complaint or a petition before the Petitions Committee. It must be the private party in the PPP process. So obviously the respondent in all cases will be the public party, whether the Treasury or whether the PPP committee or whether it is a contracting authority, like a road authority. Now, to file a petition, once a private party is unhappy about a decision that has been made by an administrative body or the public body, they have 15 days within when to file their petition. Now, we all know that infrastructure projects, PPP projects rather, are also very large, and they have a significant impact on the economy. Any delay to resolve the disputes would lead to increased costs, and that would complicate the project, because we know that in jurisdictions like ours, if a PPP tender dispute was to be filed in our Kenyan courts, we know it will take several years to be heard and concluded. So this specific act limited the period within which these disputes would be resolved. Now, before I look at one or two or three case studies, when can a private party lodge a complaint with the Petitions Committee? One is when a private party has been informed that they do not qualify to participate in the tender. Secondly, when a bidder is not shortlisted at the qualification stage. And when a private party has been informed that their technical bid has not met the tender requirements. And finally, when a private party has been informed that they are not the preferred bidder, that is the preferred bidder is more or less the end of the tender process. Now, between 2013 and 2016, there were 8 PPP procurement transactions. Of these 8, 4 of them faced various contestations. One of them is what we normally call the Lamu Coal Power Project. Now, in this project, the private party complained that they had been unfairly disqualified due to a typographical error in the calculations of what is known as the fuel charge rate. they also complained, the private party also complained that there was a consortium that was reconstituted after the final awarding of the tender. However, the petitions committee, that is the tribunal hearing the matter, concluded that the contracting authority being the Ministry of Energy, had sought clarifications from the bidders before announcing the preferred bidder. And therefore, the petitioner had an opportunity to the petitioner had an opportunity to seek that clarification at that time. Secondly, the petitions committee also found out that the reconstitution of the consortium was in line with the PPP Act of Kenya. Another petition is what you can see up there, known as the ITNL International and Henry Holdings versus Kenya Highways Authority. This was a finance, design, build, maintain, and transfer of various roads in about 6 counties. Kenya has 47 counties, so these are about 6 counties on the western part of Kenya, totaling about 10,000 kilometers. The petitioner's bid was 4.28 billion Kenya shillings, while the interested parties' bid was 4.45 billion. Now, after the petition committee went through deliberations in this particular matter, what came out was that the contracting authority, the contracting authority during the evaluation used a criteria that was not in the RFP. Secondly, the RFP had numerous ambiguities. What the petition committee concluded was that this whole transaction would have to be retendered and an appropriate RFP prepared, so that because where we have competition, the RFP must communicate very clearly to the bidders. The other petition that you see there was APM Terminals versus Kenya Ports Authority. This was a PPP where which was at Mombasa, that is at the coast of Kenya, and that is where the Kenya Ports Authority is based, and it was to build a second container terminal. The issue was that the petitioner failed at the preliminary evaluation stage because their bid security was valid to a period that was not that was less than specified in the bid document. The petitioner pleaded that this was a minor deviation, but the petitions committee, after hearing the matter, rejected that prayer and stated that the bid security was not a minor deviation. And however, the petitions committee also noted that the contracting authority had not done the preliminary evaluation in strict compliance with the bid document, and therefore the petitions committee directed that the contracting authority should reconduct that preliminary evaluation so that it meets the exact specifications that are in the bid document. Now, these are just a few of the cases that we have that we went through. But basically, what was noted was that there was largely a failure by the public party to comply or to stick to the evaluation criteria that was in the bid document. And anytime the public party does not stick to the criteria that is in the evaluation document, then obviously the petitions committee or the tribunal that hears that dispute would allow a complaint of that nature. I think I've done my 10 or so minutes. How many more minutes
Thank you. That's the end, James. Thank you so much.
Okay, thank you.
Okay, so we are going to move on now to the part 2 questions, and there are actually a few in the chat box. So Rohit, I'm going to start with you. There's actually 2 for you. I don't think they can necessarily be combined, but one is about the issue of head office costs and contractors' claims from Mark Obeya. And then Diana asks, what is the nominated subcontractor's place in claiming for the prolongation costs caused by the main contractor? Should this be done directly to the developer or the main contractor?
Yeah. So let me first take about the head office overhead cost claims. Basically, the head office claims are claims wherein a contractor says that it was not able to recover its head office cost because of delay or prolongation caused by the employer. This means that extra money has been spent by the contractor on its head office resources and staff, which, had there been no delay caused by the employer, would not have been required to be spent. Now, how do you claim such a kind of a cost? There are 2 important prerequisites. Number one is it has to be shown that really there is a loss suffered by the contractor for its head office cost. By when I say how it has to be shown, is to be shown by way that there were no other projects which were available with the contractor at that point of time, or there were new projects which the contractor could not bid because its head office staff was busy working on the during the prolonged duration of the project which has been delayed, or where the project the claim is being put under. So let's say if I am a contractor and I am doing X project and it is delayed, so I will be able to claim my head office overheads only if I am able to establish that my head office people have spent time on the project which I am doing, and there has been other projects which this head office people could have undertaken, but because the head office people were busy with this project, so I had to let go the other projects and I could not participate or bid for the other new projects. How do you calculate that? In order to calculate the head office costs, what you can do is you can probably either use actuals, where in case what are the number of people who are working in head office on the project in which the claim is to be raised. Alternatively, there are formulas, industry formulas, what we call as Hudson formula, Emden formula, Ishley formula, wherein you can calculate the head office overhead cost using those formulas. These formulas generally require percentage of head office overheads, which can be derived from the past profit and loss account of the contractor, to see that, okay, a contractor is spending 5%, 7%, 10% of its total revenue towards head office. So using that percentage and using the formula, it can be the head office overhead costs can be claimed. Now, talking about the next question, wherein I have been asked that in case there is a nominated subcontractor and this nominated subcontractor wants to place in its claim for the prolongation cost caused by the main contractor, then in such a situation, whether the claim should be submitted directly to the developer or to the main contractor. My answer in this case is that the nominated subcontractor, even though is nominated by the developer and put on to the main contractor to work under the main contractor, but since the subcontract of the nominated contractor is with the main contractor, and therefore the prolongation claim has to go from the nominated subcontractor to the main contractor. Nominated subcontractor, unless the terms of the contract are such that he can raise directly to the developer, in most circumstances, which would not be the case, the nominated subcontractor would put its claim for prolongation onto the main contractor, and the main contractor in turn will use that prolongation claim of the nominated subcontractor to submit the claim to the employer in case the employer delays are the reasons for the nominated subcontractor to be raising its prolongation claim. There could be a possibility that the nominated subcontractor has been delayed by the main contractor. Then in that case, that claim for prolongation will not go to the main employer. It will remain with the main contractor only. Thank
Okay.
you.
Thank you, Rohit. And I hope that's answered your question, Diana. There's been a little bit of a discussion, I don't know if you've seen it, Paul, about mediation. Francis says that on one of your slides, you mentioned that mediation is not effective. Andrew has provided a written answer. So just wanted to get your views on mediation, Paul.
Yeah, well, basically mediation is, unless the parties agree otherwise, it is not binding. So it's really up to the parties to decide whether or not to accept the mediation process to start with, or to accept the outcome of that mediation process. So you find that for large contracts in particular, there is no, shall we say, benefit for the employer to get involved in the mediation process. So therefore, what we've seen is that people don't bother with mediation, they go straight to arbitration. So, what I was saying in my slide is this. Whilst in certain types of industries, mediation can work, when it comes to large construction projects, they don't seem to work.
Andrew, did you want to add anything to that?
Yes, I will. I don't know if you can get me back on the camera, but look, it's different vehicles for different purposes, and what we're really looking for, and I say this as a lawyer, is for dispute avoidance as opposed to this having a fully fledged formal dispute process. And there's no question that mediation, although you can be quite cynical about it, it can work very, very effectively for parties to understand their position. But as Paul says, it's not going to be enforceable. I mean, certainly in some of my experience in Australia, some of the mediation regimes there were enforceable. But you're not going to get a mediation as a final means of dispute resolution on a major construction project. So to me, it's a thing that should be encouraged, but it has to be recognised that it is a means of looking to avoid formal dispute resolution, as opposed to being the only form of dispute resolution.
Yeah.
If I may just add something, maybe something that wasn't picked up. What the 2017 form has done is to embed mediation as part of the role of the engineer or the employer's representative. The 42 days of consultation is actually a mediation process. So that process has not been thrown out altogether. It has been maintained, only that it's been now called one of the roles that the engineer must perform.
Yeah, I would say, mediation, I'm a big advocate for it, like Andrew, and I think it can also narrow issues. So if there are a lot of issues that are outside of the contractual framework, that can perhaps be narrowed down through a mediation. And then the issues are the list goes from 20 to 10, that in itself is an achievement. I know here, of course, we have the issue in parts of the Middle East about without prejudice and things like that comes up when you speak about mediation. Mm-hmm. So just moving on to another question. If we turn to Mr. Kihara, there is quite a long question. I don't know if you can see it, from Irene Kashendi, who is asking about, I believe Warimu is, so it's about Bahat's question. Okay, sorry, it's disappeared now. One second. I think Warimu clicked answered, so it moved to the, so it's on the Lamu power plant. The dispute started at the PPP committee, escalated to the High Court, the NET tribunal, just to name a few. Do you think that the solution lies in legislating how long PPP disputes should be determined by any body? A good example is what the public procurement law provides, that tender disputes by the court should be restricted to 45 days.
Yes, thank you very much. I would want to, there were two questions. There was one, I think, by Bharat, but I think I typed the answer there, but I don't see it. Okay, but the other question about both, what happens is, if you look at the Kenyan case and that Lamu coal dispute, what happened is that each one of these courts have got their own mandate. Now, the petitions committee was only looking at issues to do with the procurement. That is where our mandate stopped. We looked at, was the procurement done properly? So we looked at the procurement process from the beginning. At the conclusion of that procurement process, our mandate ceases. Now, there's the High Court now. The High Court will look at other issues, general issues, matters to do with the Constitution, etc. However, there is the Environment Tribunal. That is it's a different tribunal. Its mandate is to look at matters dealing with the environment. And you will find in this particular case, we looked at the procurement and we said it was okay. And we said that is where our work ended. However, the Environment Tribunal looked at the environmental dispute and actually, so to speak, terminated that project. So each one of these bodies have got their own mandate. Now, ours specifically is limited, our hearing is limited because of the issue of cost and escalated costs that I talked about. But the Environment Tribunal, I believe, can hear this matter at any time a petition is raised in that Environment Tribunal. Also in the High Court. I think you can approach the High Court at any time. But of course, in all these projects, it is always easier to deal with the disputes from the onset, because we don't want a project going on for 5 years or 10 years, and then an issue arises, and then the court or tribunal terminates the project. The other question that had been asked by someone, I can't see it here, but I typed the answer. The issue was one of the participants asked, what do we do? Because he stated that most of these contracts are geared towards, or rather, they are normally awarded to government employees. I really don't think they're awarded to government employees. These projects are awarded to individuals or companies out there, but with the connivance probably of the government officials. So the government officials try to assist that party win that tender. So he asked, what do we do? My proposal would be this. Everything, the nucleus of this procurement is the evaluation criteria. The evaluation criteria should be as detailed as possible. It should be as clear and as certain as possible, so that there is absolutely no other interpretation that can be given to anybody. Secondly, we need to have a mechanism where the evaluation criteria goes through checks and balances, so that we know that this evaluation criteria has not been prepared in a way to assist a party win that tender. Thank you very much.
Thank you, James. I believe Mr. Osorio has to leave us. So thank you very much for your excellent presentation. We really appreciate you sharing the financer expectations. Thank you so much. But we'll continue on with questions with questions and answers now. There's one from Sanjeev, which I think the whole panel could perhaps give a 1-minute view on. It's about the issue of impartiality and independence of dispute resolvers. And whether there ought to be harmonized guidelines on their ethical conduct. How effective are the timeline provisions when tribunals fail to adhere to contractual timelines provided for decision-making, despite the parties having discharged their payment obligations? And what impact does such delay have on these fundamental principles? What recourse is available to parties who have agreed to their disputes effectively and resolved, yet this is not possible given the lapse on the part of tribunals? So we know that obviously the different bodies like ICC, CIR, RICS as well, have codes of conduct. All the regional arbitration centers do as well. Does the panel have a view on this topic of impartiality and independence? Andrew, would you like to start?
It's going to, okay.
Oh, sorry.
Yes, sorry, I'm sorry, was somebody else speaking then?
I think, was that you, James, who wanted to go first?
I was just going to go first.
Sorry, it wasn't me. Okay.
Okay. No, but you find that it is one of the reasons where an award or a determination can be overturned, and there are consequences that can be imposed by the High Court. So it may not be a free pass. And I think if I understood the question correctly, is if you paid your fees and the tribunal fails to either, I don't know whether it's talking about an arbitral tribunal or a DAB. Let's say it is an arbitral tribunal, and they fail to deliver or make an award, or they make an award, but they're not impartial. In our law in Kenya here, there is room to go to court, to the High Court, and have that award overturned. Now there will be consequences. So in the case of a DAB, if the DAB does not give their determination within 84 days, they're running a risk of having to refund any money paid to them. So there are consequences.
Andrew?
Yeah, perhaps my answer is to start from quite a high level and take a step back. I mean, the short point is that whichever form of justice you go for, whether that's in front of the legal system of a country or with a group of selected people for effectively private justice, you run risks, and there are checks and balances in the various systems. I mean, obviously, if you go into a court system, certainly as far as I'm British or Australian perspective, you can be pretty certain that a failure by a judge to deal with the case will be scrutinised, and there are various appeal processes. When you go down the private track, undoubtedly, there's all sorts of potential risks, and that's one of the reasons why. And I did notice a question that's been asked in the chat about the ICC. That you go to an organisation like the ICC because, well, it's expensive, but generally speaking, the ICC takes upon itself the job of policing its arbitrators, but you pay for the privilege. Insofar as you're in a situation where it's an institutional arbitration or you're in an ad hoc arbitration, and you've got arbitrators who aren't doing what the parties are doing, well, it's a contractual situation, a contractual difficulty. Now, obviously, both parties could get together and look to get rid of their arbitrators, and they're perfectly entitled to do that. Of course, invariably, if you're in a dispute situation, the parties are often people who are less likely to be coming to any sort of agreement between themselves. But that might be a scenario. But then the other point that's just been mentioned is, if you're an arbitrator or an arbitral panel, it is not above the law. And most legal systems that recognise arbitration will have an arbitration law, which will enable parties to go to those courts for the purposes of having the behaviour of the arbitrators checked. That's a slightly different thing from having their awards checked, because most or many jurisdictions have excluded the ability of the courts to actually challenge the nature of the award if it's a properly awarded award. But yeah, as regards the behaviour of the arbitrators, you don't want to be in this position. But if they're failing in their duties as arbitrators, it's necessary to go to court to overturn it.
Rohit, do you have a viewpoint from the view of an expert? I mean, obviously, we're both based here in the Middle East. At some point, there was, issues with regards to experts, arbitrators, and the fact that they could be criminally liable for things that happened, whether or not there was bias and things like that. That has since been repealed. But from an expert's point of view, how do you view the issues of impartiality?
Yeah. So, Yasmin, I quite a lot agree with what Andrew said. You see, the question which has been put forward is that what happens in the event the arbitrators do not adhere to the timelines which have been agreed with the arbitrators or in the contract or in the arbitration agreement on the decision to be on the decision to be given by the arbitrators. Now, this happens a lot. I have come across such kind of situations many a times in Middle East arbitrations and all. But generally, those situations are coming in ad hoc arbitrations rather than institutional arbitrations. So, in ad hoc arbitrations, when there is no one to govern and supervise and see how the arbitrators' behaviors are, then definitely you run that risk. And that's the reason why people prefer going to EAIAC, ICC, DIAC, DIFC, and all these places in order to ensure that you have got an institution who is there, who is ensuring that the arbitrators are adhering to the procedural timetables and they are adhering to the timelines which are there. Saying so, as Andrew said, that in case you have a situation of ad hoc arbitration and still the timelines are not being abided and there is extensive amount of delay, the parties can come and either replace the arbitrators, but generally that is sometimes an impractical solution because when you have gone so far ahead in the arbitration, a change of the arbitrators, will it be really right decision to be taken by the parties is a question mark. Alternatively, courts can be approached wherein the arbitration law of a country generally has got certain timelines, and in case those timelines are not adhered to, the courts can definitely be approached. That's what is my view. Thank you.
Just going on the topic of arbitration, a question from me. Obviously, arbitration has changed quite a lot over the years. It is expensive, it is lengthy, not in some countries as long as a court case, perhaps, but it's definitely not as cost effective and as efficient, perhaps, as it once would have been. We've seen adjudication. For example, South Africa has a draft bill that is supposed to be passed imminently, introducing prompt payment legislation, aka adjudication, into the industry. We know that adjudication has had great success in the UK, in Australia. It's being rolled out in Canada now as well. What do we see the options are, on the continent for adjudication? Is it something that we see would work and would help disputes be managed more effectively and efficiently? Anyone would like to take that? I know, Andrew, I think I picked up that you're Australian, so you may have a viewpoint on adjudication.
Yeah, sorry, but are you talking about statutory adjudication?
Statutory adjudication, yes.
Well, maybe Andrew can talk to the experience in Australia, where they do have statutory adjudication, but yet more disputes are resolved at contractual adjudication level. Is that not the case, Andrew?
Yeah, I mean, well, my experience is both UK and Australia. Look, there is absolutely no question that the jurisdictions that have introduced adjudication legislation, and just to make clear to everybody, in case there's a bit of confusion, when we're talking about statutory adjudication, which also has a sort of spin-off called contractual adjudication based on the statute. We're talking, that's something that's very different from these dispute adjudication boards which are being discussed. They're wholly separate. But in terms of this statutory adjudication method, it's been hugely successful. Absolutely no doubt about it. And as has been said, it started off in the UK. And it has to be combined. It's not just the dispute resolution process itself. It's a combination of two, three factors. One is a payment regime, which has to be strictly complied with, and you can go to a very quick dispute resolution process, which then has to be abided by, although it is possible that you can subsequently overturn the decision. So it's not binding in a formal sense, but it is, for all intents and purposes, often the dispute, the only dispute that's heard. So what you have to have is a legal system that can back it up, that is prepared to say there may have been some rough justice in relation to the way in which the adjudication system has applied, or the particular adjudication has been heard. But nevertheless, the legal system the judges in the legal system are going to support this, because as a concept, it is what we want to achieve, which is to make sure that cash flow to contractors is paramount.
Stop. Yeah.
So that's the issue, I think, for Africa. It's whether or not the different jurisdictions will have the legal system that is prepared to take that step. And it's a leap of faith in a way, because quite often adjudication decisions are being enforced where there is a slight discomfort in the courts. You can just see it about enforcing, but the public policy element is enforce it, because overall it is a good thing. I mean, I'm not saying every adjudication is enforced, not all of them by any means, but that's the thrust of what you have to have.
Paul, did you want to add something to that?
Yes, I wanted, because I mean, if you look at the London Olympic experience, where they had, by law, they had to have a board, so they had to have such an adjudication as part of the process. They also had a panel below that, and all the disputes, or shall we say claims, were settled at that level. They never went to adjudication. And speaking to the conference the other day, talking to guys from Australia, and they basically tell me, although they do have such adjudication, they hardly use it. So I thinking about the Africa context, if you have a good process like they have in 2017 now, where payment is mandatory, then whether it is binding, whether it's binding or binding and final, then I'm not too sure whether such adjudication would add much to it. That's my concern. And the other concern I have is to do with relationships.
Yes.
You always want to preserve relationships.
Yes, thank you. Well, that's been a great question and answer session. We have about 10 minutes left. And what I would like to do now is to close the session with 2 minutes from each of our esteemed panel. What is your key takeaway from this session for governments, financiers, investors, and dispute practitioners in Africa, according to you? So let's start with Andrew. Is Andrew still there? Oh, we seem to have lost Andrew. Okay, Rohit?
Yeah, so my key takeaway is, first of all, I enjoyed the webinar. I enjoyed the interactive session. You know, so many questions have come up. My key takeaway from this webinar is, things have to move, more systematically. Construction disputes are complex disputes, at times expensive dispute. Experts, legal, experts and domain experts, etc., have to be there. Definitely, adjudication is one of the best methods in case it can be resolved. But in my opinion, adjudication has gone way ahead in developed economies, in developed world, but probably in certain other countries where adjudication practices are still have not developed to the extent they might have developed in probably some of the other countries. But definitely, for a contractor who is in the middle of a project and he has got huge sums of money at stake, adjudication, if it can be done during the course of project execution, is definitely a very good thing. But in my personal view, I've seen in Middle East also that adjudication is not developed the way it has developed probably in Europe, in US, and in other parts of the world. And still, even if adjudication is there, part of the contract, still after going through the adjudication process, people have the parties have gone to arbitration. Either the losing party or the winning party have gone to arbitration. But definitely, adjudication is the next thing which construction contractors and developers and employers should be looking forward to. Thank you.
Thank you, Rohit. James, do you want to give us your key takeaways?
Yes, there I am. Yes, mine would be After listening and after the discussions that have been going on today, one is that I realized that everything construction revolves about dispute resolution. How do we resolve construction disputes? That is the question. That's what we've been discussing today. And what that tells me is that disputes are at the core of the success of any of these infrastructure projects. So in future, we need to look deeper at which is the best system or mode of resolving construction disputes, whether at the tender level or after signing of the contract. We need to look at it because, various jurisdictions are using different methods. We have statutory adjudication, we have the FIDIC, we have hybrid systems, arbitration, and the normal civil courts. I think we need to look more deeper and see which would be the best system and at what stage of resolving these disputes, or better still, avoidance of these disputes. I think we need a longer and deeper debate as to which is the best system. And again, not for all construction projects. I think each construction project is different from the other. That is what really I take home today. Thank you very much.
Yeah, absolutely agree, James. There's no one size fit all solution for this issue. Paul, could you give us your closing remarks?
Right. My takeaway is clearly on the continent, we're going to have bigger and bigger projects, mostly in the PPP field. And the disputes are going to increase. There's no question about it. So we need to figure out a way or a mechanism which will give us solutions which are not too expensive. Will not delay the project themselves. So that's what we need to think about. That's basically my takeaway. We're looking at a period which is going to be fairly turbulent in the field of disputes in construction.
Definitely. Well, thank you all. That's all we have time for. And I would like to thank all the speakers. Unfortunately, I think we seem to have lost Andrew, but we thank all the speakers for their contributions. And we also thank the audience for all of the engaging questions. I always love doing webinars for the continent because the amount of question and answer interaction is always so robust and such great quality. So thank you very much. It was a pleasure to moderate today, and I will hand it back to Warimu to take us through the next steps.
Thank
Asante
you.
sana.
Thank you, Asante sana. Thank you very much, Yasmin. And thank you again to the incredible speakers. Thank you, Yasmin, for the wonderful moderation and very cleverly going through the Q&A session. I'd like to thank again our sponsors, Alta, Mimi, and Masin Project, and our webinar supporting organizations, the Dispute Resolution Board Foundation, and the Royal Institution of Chartered Surveyors, without whom this would not have been possible, really. And to you, delegates, I'm sure you will agree with me that the discussion has been very robust. We have had, I think, over 40 questions, most of which have been answered. And if they've not been answered, please look out for the webinar, post-webinar report that we shall be circulating, which will have most of the questions. So back to my closing, I thank you again for joining the webinar. Thank you to our sponsors and partners who have mentioned, and to our other partners who had mentioned before, but just to briefly go through them. We've had great support from the Africa Finance Corporation, from the Africa Legal Support Facility, from the East Africa Law Society, CIARB Kenya, CIARB Nigeria, NCIA, LSK, the Architecture Association of Kenya, ULS, ICAMEC, TLS, TIARB, CRCICA, LASIAC, CIARB Nigeria, CPMLP, among others. Now, please do sign up for the Energy Disputes webinar that we are going to be having on that Thursday, 8th of July, 2021. If you look on the chat box, there are further details on how you can register. And in there, during that webinar, we shall have a further robust discussion on energy, downstream power, oil and gas disputes. So please do join us. And also join us for the annual conference that's going to be on the 27th to 29th of October. Again, please email us for further details, which will also be circulating. Once again, thank you very much, Yasmin Nashawati, Rohit Singhal, Andrew Sims, James Kehara, and Paul Karekezi, and Osarui Orobosa from the Africa Finance Corporation. Asanteni sana. Until next time, everyone, keep well, keep safe, and God bless you all.